Hi, I'm Neha Matthews, and you're listening to Three Things, the Indian Express news show. On November 9th, 2019, a constitutional bench of the Supreme Court, constituting CJI Ranjan Gogoi and Justices S.A. Bobde, D.Y. Chandrachud, Abdul Nazir, and Ashok Bhushan, delivered a unanimous verdict for the Ayodhya dispute, bringing an end to a centuries-old battle that had come to shape our country's socio-political landscape. Outside the court and in the lawns, celebrations broke out among a section of bystanders, journalists, and lawyers. Here's what it sounded like when the verdict came out. On this episode of Three Things, we unpack the Ayodhya verdict, the reaction, and what lies ahead, so stay tuned till the end of the episode. First, Apurva Vishwanath, who reports on matters of law for the Indian Express, summarizes the verdict.
Essentially, the Supreme Court has ruled that the 2.77 acres of disputed land, Ramlala Virajman, the deity, has title to it. They've basically declared the title in favor of the Hindus. And in doing so, they have negated the claims of the two other parties involved in the case, where the Allahabad High Court had given them one-third and one-third title to the disputed land, which is Nirmohi Akhara and the Sunni Waqf Board.
The Supreme Court also announced that the Nirmohi Akhara neither had managerial rights or title to the disputed land. For the Sunni Waqf Board, the court said they had not been able to prove possession and therefore cannot get the title.
And then the court actually goes one step further and says, because of these two events of 1949 on 22nd and 23rd, the intervening night between 22nd and 23rd December, idols were placed under the central dome of Babri Masjid, and that was desecration of the mosque. Before that, in a previous riot, one dome of the Babri Masjid was demolished. And again in 1992, you see the Babri Masjid being torn down. The court criticizes these events and says that they were against the rule of law and the assurances given to the Supreme Court. To sort of remedy this, the court says that they will use their powers under Article 142 of the Constitution, which is a power to do complete justice, pass any order, decree to do complete justice. And the court says, in lieu of the demolished Babri Masjid, the Sunni Waqf Board will get 5 acres of land somewhere in Ayodhya. And as far as Nirmohi Akhara is concerned, the same principle, using their 142 powers, the court says that the trust that will be formed now by the central government, Nirmohi Akhara will have a place in that trust.
Remember, this was a civil suit, a fight over title for the disputed land. But as the Supreme Court said, it is a dispute whose origins are as old as the idea of India itself. So this verdict sets a historical precedent, with a court of law deliberating on a contested sacred space.
If you look at the role of constitutional courts across the world, I don't think any constitutional court has gone into a fact-finding expedition into whether there was an ancient temple underneath a demolished structure of another religion. And the court also recognizes this, and they repeatedly say this in the judgment, that the journey that they are about to embark is historical and unprecedented. And the court also reminds itself that as a constitutional court, they will not go into the job of interpreting religious texts. While the Allahabad High Court did interpret hadiths related to whether the Babri Masjid was a valid mosque or not, the Supreme Court says that we will not do that because we shouldn't be interpreting religious texts. So the court also realizes the significance of this ruling. And also, if you see how they wrote the judgment, because they wanted to speak in one unanimous voice, the judges do not mention who actually wrote the opinion and who agreed with the opinion. They say that they don't put that out, and they say all of us want to speak in one voice. So the court also understands the significance of this ruling that way.
To help you understand the verdict better, we unpack it bit by bit, explaining the Supreme Court's answers to the main questions that define the dispute. First, who built the mosque and what structure existed beneath it? On previous episodes, Apurva has explained that the Muslim side argued that the mosque had existed at least since 1528 and was built by Babur's commander Mir Baqi on his instructions. The Hindu side, however, called the mosque an invalid structure built over a Hindu temple that was demolished. To prove this allegation, they relied on the Archaeological Survey of India's findings that point towards the mosque being built on a pre-existing structure. Here's what the Supreme Court ruled on this matter.
So the first aspect is who built the mosque and when was it built. Interestingly, the Supreme Court does not go into this question in the verdict. And in fact, they criticized the High Court for trying to find answers to this question. And they say because the rival contestations of both the parties begin sometime after 1860s. 1855, there is a riot. Subsequently, there is some contestation between the two parties. And 1885, you have the first suit filed by Gopal Singh Visharat. So the court says, why do we need to go into this question? What happened before 1860 is irrelevant to us. So they do not want to answer who built the mosque and why. The second answer is the court also looks at instances where the Hindu side also has referred to the Babri Masjid as a mosque. So they look at claims from dating back to the 19th century and say, look, in many instances, the Hindus also refer to this as a mosque. So do we really need to go into this question of who built it and when? And the court says, how does it matter who built it? They finally conclude saying, we think Mir Baki built it by himself or at least on the command of Babur, but they don't really ascribe any significance to it. So that's one part of it. The second is whether the Babri Masjid is a valid mosque. Like we've discussed before, the Hindu side had been claiming that the Babri Masjid is not a valid mosque because it was built against the tenets of Islam, and there was an ancient Hindu structure underneath the Babri Masjid when it was built. So the argument was that either a Hindu temple was destroyed to build the Babri Masjid or that it was built on the ruins of an ancient Hindu temple. So here, the court does not, in as many words, say it was a temple. In fact, only in one instance, they say that the underlying structure could have been a temple, but they indicate that it was some sort of an un-Islamic structure with inscriptions in Devanagari script. So the court does hint that there could have been a temple underneath, but they categorically refuse to say whether a temple was destroyed to build the Babri Masjid or whether it was built on ruins. They say that the ASI evidence is inconclusive on that aspect, and with such evidence, they really can't make that conclusion.
The second point of contention: who had possession over the 2.77 acres of disputed land, which includes the inner courtyard that contained the mosque and the outer courtyard? This determines the final verdict.
So for this, the court looks at three timelines. You have between prior to 1856, which is when the British annexed Awadh. You have from 1856 to sort of when the suit began, from 1856 to 1949 and 1949 onwards. So for these three timelines, the court says, well, we do agree that after 1856, the Muslims had possession of the disputed sites. For starters, the Babri Masjid stood there till 1992. And they say that the Muslims never abandoned the Babri Masjid, even when it was locked up in 1949 and was handed over to a receiver. And the court also says that there were prayers performed at the Babri Masjid. After the 1934 riots, they say at least every Friday namaz was performed. There was someone to lead the azan call. So the court goes in favor of Muslims for the period which is starting from 1856. But the problem really comes of a pre-1856 era. So as we know, when the British annexed Awadh is when they started keeping records of either land or everything else. They started maintaining records for everything. So the court relies on, say, police reports during riots, court documents, and land records of that era. But for the pre-1856 era, the Muslim side cannot show exclusive possession. Here, the court says of a pre-1856 era, we think other religions, that is the Hindu side, also had access to the Babri Masjid. And we know that because of the Hindu side's evidence which they had advanced, which is reports of travelers, gazetteers, and oral testimonies of people who claim that they'd been there and were performing puja at the disputed site. So the court says since the Muslim side could not prove from 1528 when the Babri Masjid was built to sort of 1856, the 300 odd years, the court says the Muslim side is conspicuously silent on whether they had exclusive possession.
So this worked against the argument that the Muslim side had made about claiming the title through adverse possession of the land.
Adverse possession is basically squatters' rights. So assuming you had the title to the property, but I built something there and I was there for about 400 years, and now I am claiming title for it. The onus is on me to prove that I had exclusive, continuous possession of that place. So the court says while the Muslims have failed to prove exclusive and continuous uninterrupted possession, The same burden is not on the Hindus because the Hindus are not the ones claiming adverse possession. The Hindus say we always had the title to it. So, in that way, the Hindus have a lesser burden of proof to sort of say that only we had exclusive access. So, even though the Hindus did not have exclusive access, they get the land. And since the Muslims fail to show exclusive access of land, they don't get the title to the disputed structure.
Another important question that came up was the third party, the Ram Lalla Virajman, which, as we know, went on to win the suit. They claim that both Ram Lalla, the deity, and the land, which Hindus consider the Ram Janmabhoomi or the birthplace of Ram, whether both the deity and the land were juristic persons who had legal rights.
So the first aspect of this, whether the deity has juristic personality, the court accepts that the deity has juristic personality, and also from the Sunni Waqf Board, this was not really in contention. They had also agreed that the deity has juristic personality. So the real contention was about Janmasthan. While the Hindu side said that the Janmasthan, the entire area where Ram was born itself, should be referred to as a juristic person because of the belief of the Hindus that Ram was born there and this aspect of divinity to that land. The court curiously makes this observation that a reason why a deity or any inanimate object for that matter is conferred the status of legal person is out of necessity to ascribe certain rights, duties, or liabilities. The court says we have to call the deity a legal person because the deity owns land, the deity wants to sue somebody, and somebody else has to sue deity. So, sort of to manage all of this, the deity is conferred legal personality. For the Janmasthan, there is no such necessity. The court says the only thing that follows from giving the Janmasthan a legal personality is that it extinguishes the rights of every other party. So if the land itself is a legal personality, nobody can encroach that land. So the claims of the Muslim side falls flat from times immemorial, so to say, from when Ram was born there. So the court says the only consequence of ascribing legal personality to the Janmasthan is extinguishing everyone else's claim, and there is nothing else to it. So the court refuses to give that relief that the Hindus asked for.
One of the defining moments in the history of this dispute happened in December 1949, as Apurva mentioned in the beginning. Idols were placed under the main dome of the Babri Masjid. The Hindu side claimed that this was a spontaneous appearance of Lord Ram. The Supreme Court on Saturday disagreed.
The Supreme Court looks at letters that the DM had written at that point and correspondence between government officials on the intervening night of 22nd and 23rd December in 1949. And the court concludes that that was an attempt to desecrate the mosque and calls it illegal. And subsequently, the court says after that, even in 1992, the mosque was demolished. So all of these things, the court strongly criticizes the actions that took place. They don't say who exactly did it, because the court can't really go into that question without a criminal trial. But the court says that there was an act of criminality when all of these events took place. So that's a strong indictment of the events that took place. But who did it is a question that the criminal trial has to answer.
So this brings us back to how the Supreme Court goes beyond just the land suit and, in the name of equity, orders that the Muslims be given 5 acres of either acquired land near the site or at a suitable prominent place in Ayodhya so that they can build a mosque there. What does this idea of equity mean? And will it serve to protect from more such disputes between communities over sacred land?
So here the court does talk a lot about equity and good conscience and the secular fabric of the nation and all of these themes. And the court says because of the events of 1949 and 1992, the court does have to, in some sense, give some justice to the Muslim side. In a way, in lieu of the Babri Masjid that once stood there, which was demolished, the court says the 5 acres will be allotted to the Muslim side. So here, interestingly, the court makes these observations in one sentence, in one paragraph. The court, in fact, says even if there were certain wrongs committed by the Mughal kings, the answers to these claims that arose from the wrongs committed by the Mughal kings does not lie in law. It probably lies in equity, but we are not the right forum for that. So the court also says that even if the Mughals committed certain wrongs, it is not for the present generation to sort of be targeted about it. That's really how the court justifies allotting 5 acres to the Muslim side.
So what's next after the verdict? We're going to be discussing how the Sunni Waqf Board reacted to this, but should the judgment be treated as final or is there scope for review?
The Sunni Waqf Board has already come forward and said that they will not file a review. But any other party which is not satisfied with can seek a review. But remember that the grounds for a review petition are very narrow, and the parties have to show that there has been a very apparent error on the face of the judgment. And these errors should be very grave and something in the nature of one party not being heard before the order was passed, or the court overlooking a valid precedent, or misinterpreting a provision of law. And these are very technical reasons why a judgment is usually reviewed. But the substantive part of the judgment, I would say, has attained finality now that the Constitution Bench verdict is out.
Ayodhya, however, is not the only contested space in India. In Varanasi, there is the Gyanvapi Mosque built by Mughal Emperor Aurangzeb, and the Sangh Parivar claims that this site originally held the Kashi Vishwanath temple, which was destroyed to build the mosque. Then in Mathura, there is the Shahi Idgah Mosque, which lies on the site considered to be the birthplace of Lord Krishna. Will the Ayodhya verdict set a template for such future disputes?
There's been a lot of conversation about Mathura and Kashi being next, because yesterday Kashi was trending on Twitter and there was a lot of conversation around that. But the judgment sort of does not provide a template for future claims of this sort. The judgment is clear, like I just said, the line that they used, saying that even if there were wrongs committed by the Mughal kings, the answers to those do not lie in law and not before this court. So the court does say that you can't find answers to those in law. Here is where the Places of Worship Act becomes very important. So the Places of Worship Act, what it essentially says is all religious places in India will be as it stood at 1947. So any conversion of this religious place is prohibited in law. So if at 1949 there is a temple in Kashi, it will be a temple. If there is a mosque in Mathura, it will be a mosque. So the only exception that the legislation creates is for the Ram Janmabhoomi. They say because there were civil suits that were already pending, the legislation made an exemption for Ram Janmabhoomi. And now that this case has sort of attained some sort of resolution legally, there is no scope, at least within the framework of law, for claims from other places like this.
Next, we look at the reaction of the Sunni Waqf Board, the Muslim side. Abantika Ghosh, who reported on this matter, joins us.
Now, the Sunni Waqf Board and the All India Muslim Personal Board, they seem to have differing ideas about the way forward for this verdict. I was wondering if, they have 30 days now, are they planning to file an appeal?
Sunni Waqf Board has clearly said that we will not go for any review or file any review petition. But so far as the All India Muslim Personal Law Board is concerned, there are clear individual opinions which seem to suggest that some people are in favor, some people are not in favor. The legal team seems to think that a review may be in order. But the final call will have to be taken by the working committee of the Personal Law Board, which is the decision-making body. So it's not clear yet whether there is a difference. Even the Jama Masjid Imam, the Delhi Jama Masjid Imam, he has also said that there is no need to go for a review. But one thing that seems to be common is that, this 5-acre land is not something we needed or we asked for. So maybe we should not take it. That seems to be a common thread between individuals.
Another common thread I was wondering is, we're hearing this from the AIMPLB as well, and on TV debates yesterday, that they believe that this is a victory of faith over facts. Could you elaborate what they mean by that?
So that phrase, if I recall correctly, was used by Hyderabad MP Asaduddin Owaisi, that this is a victory of faith over facts. So some of the facts, and this is also the reason why their first reaction to the verdict has been that it's been a disappointing verdict, is that the court held that in 1949, when idols were placed in the then Babri Masjid, it was a desecration. That's the word they used. In 1992, when the mosque was demolished, that was a violation of the rule of law. That also the court has admitted. But from there to basically uphold the right of the Hindu side on the ground that the Muslim side could not give proof of continuous prayers before 1857, also to go by the ASI evidence of a 12th century temple, when at the same time there is one place where the court says that we don't even know if it was a temple or not. All of these taken together, the Muslim side feels that the evidence that they had placed in court, and also some of the observations that the court made based on that evidence, the final judgment does not seem to reflect that those evidences have been taken into account while delivering it. So, in a sense, what many of them feel, or what they're saying off record, is that this seems to have been an issue that was prejudged. The judgment seems to have been a foregone conclusion. It's just that now it's been written out and sort of argued out in a 1056 or whatever page judgment. But it seems that they're already decided what to do. So that's why they have said that it's a victory of faith over facts.
So, how did the political parties react to this verdict? While the BJP had aggressively championed the building of the Ram Temple when they were the opposition party, mentioning it in all their campaign manifestos since 1996, the reaction of the party leaders on the verdict day was measured. As Liz Matthew, who covers the BJP for the Indian Express, reported, leaders hailed the judgment and the Supreme Court, but projected it as a victory for the country, its heritage and legacy. They followed the template laid out by top leadership that had warned against any celebrations. PM Modi made a speech later in the day, announcing that it was time to unite and the verdict shouldn't be seen as a win or loss for anybody.
लेकिन इस फैसले के बाद हमें यह संकल्प करना होगा कि अब नई पीढ़ी नए सिरे से न्यू इंडिया के निर्माण में जुटेगी। आइए एक नई शुरुआत करते हैं।
However, the reaction of the Congress party was interesting. Manoj CG, who reports on the Congress, joins us to explain why.
So, Manoj, yesterday after the Ayodhya verdict came out, Congress spokespeople came out to say that they welcome the construction of the Ram Temple. This was, however, they were silent on the topic of the Babri Masjid. And we were wondering if this stance is, incongruent with what the party had earlier said about the Ayodhya dispute.
Congress has been for some time talking about respecting the Supreme Court verdict on the Ayodhya issue, at least since the early 2000s. That has been the party stand. So yesterday when the verdict came out, the Congress Working Committee met and the Working Committee issued a 3-para kind of a stayed statement saying we respect the Supreme Court verdict and asking, every party to abide by the Supreme Court verdict and maintain peace and harmony. But after the Working Committee meeting, when Mr. Randeep Singh Surjewala, he addressed the reporters, he kind of said, the Congress is in favor of construction of a Ram Temple. Now, there was no mention of Ram Temple in the Working Committee resolution. There was no mention of Babri Masjid also in the Working Committee resolution. And Mr. Surjewala did not touch upon Babri Masjid or its demolition or its rebuilding. But he said the party was in favor of construction of a Ram Temple. Now, after the demolition of the Babri Masjid in 1992, the then Prime Minister, Mr. P.V. Narasimha Rao, had publicly committed to rebuilding the Babri Masjid. So that part was somehow missing. The Congress leaders later said, the Supreme Court has allotted 5 acres to the Sunni Waqf Board and to the Muslim side. And obviously there will be a masjid coming up. But that part was explicitly missing when Mr. Surjewala addressed the press conference. You should also, look at the fact that the one side, the All India Muslim Personal Law Board, is not really happy. They were not satisfied with the Supreme Court verdict. So there was no mention of that unhappiness also when the Congress came out. If you look at the statements issued by the CPIM or the CPI, they kind of touched upon that aspect, saying, some questions are still unanswered. So all those things were missing when the Congress addressed the press conference. That gave a perception that, the party is slightly nuancing its position as far as this issue is concerned.
Do you think there's something about maybe the last 3 decades which they've seen they're losing relevance in their Hindi heartland? Do you think that is making them shift their narrative to a similar narrative that the Rajiv Gandhi government had back in 1991?
Of course. You will have to look at the whole issue right from 1986. In 1985, Mr. Rajiv Gandhi came to power with a massive majority. And the Sangh Parivar, they started, making noises about the Ayodhya Ram Temple issue. So in 1986, the Rajiv Gandhi government arranged opening of the locks of the Babri Masjid, perhaps hoping to appropriate the Sangh Parivar agenda or to diffuse the Ram Temple movement. But, many believe that opening of the locks of Babri Masjid actually let the genie out of the bottle, which could never be put back by the Congress or by anybody. So the opening of the locks only, emboldened the Parivar, the right-wing forces to move forward with their agenda, which ended up in the Shilanyas, allowing the VHP to perform Shilanyas at Babri Masjid at that structure in 1989. And in 1991, when Rajiv Gandhi started his Lok Sabha election campaign, he began his campaign from Ayodhya, promising to usher in Ram Rajya. So the Congress was clearly trying to, balance its narrative, especially all these things, the developments came after the Shah Banu judgment, wherein there was an allegation on the Congress that, it was appeasing the Muslim clerics and all. So after that, these three, opening of the locks of Babri Masjid, the Shilanyas, and starting his campaign from Ayodhya, were all seen as the Congress's attempt to reach out or send a signal to the Hindu voters also, especially the right-wing forces. But it resulted in finally the demolition of the Babri Masjid in 1992. And then, as I told you earlier, Mr. Rao committed to rebuilding the masjid. But later, the party, kind of caught in between the Mandal and the Kamandal narrative. The Mandal, which means social justice, after the Mandal committee report, which gave actually a fillip to the parties like Samajwadi, the Janata Party, all those parties which primarily focused on caste politics. They got a fillip in North India. So the Congress started losing those votes. And then the Kamandal, the BJP's ascension, ended up Congress losing the Hindu vote also, a considerable section of the vote also. So last 3 decades, the Congress kind of lost its ground in Uttar Pradesh, Uttarakhand, which later became Uttarakhand, Bihar. The Hindi heartland, the Congress started losing the grip and they could not do much about it. So that is the background of the Congress's problem vis-a-vis the Babri Masjid issue.
You were listening to Three Things by the Indian Express. Today's show, as always, was edited and mixed by our producer, Joshua Thomas. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.